Thank you all for coming to this very timely event to discuss statutory interpretation and how much we should care how Congress really functions when interpreting statutes. We're pleased to welcome Professor Sachs and Professor McCubbins, who I assume you both know, but Professor Sachs is a scholar of civil procedure, constitutional law, Anglo-American legal history, and conflict of laws. He joined the Duke Law faculty after practicing in the litigation group of Mayor Brown in Washington, D.C. At Duke, Professor Sachs teaches civil procedure, conflict of laws, and seminars on constitutional law. Professor McCubbins is an interdisciplinary scholar whose work explores the intersections of business, law, and political economy. He joined the Duke Law faculty in 2013 and holds a joint appointment in the Department of Political Science. Democracy and the rule of law. Please join me in welcoming them both.
Well, thank you all very much. Thank you for the introduction, to FedSoc for organizing, and for all of you for coming. I really appreciate it. I'll try and keep my remarks somewhat brief so we have more time for Q&A. Topic for today is how much we should care about how Congress really works when we're interpreting federal statutes. The past few years have seen a big increase, I think, in empirical research on how Congress actually functions and attempt to connect that up to theories of statutory interpretation. We know a lot more about the institution than necessarily classic example over which there's a lot of debate is legislative history. How much do we look to committee reports and other things that are generated during the process of creating a bill? How much do we look to the drafting manuals that the various houses maintain? How much do we look to other outputs? So, for instance, some committees in Congress actually don't vote on the text of bills. They vote on bullet points that they then have their staffers turn into the text of bills to create the 1,000-page monstrosities that no one reads before they have a floor vote. And so part of the question is, what do we make of that whole process? Does that mean that, in fact, the text that nobody has read matters less than it otherwise might, and that we should pay more attention to the bullet points, the markups, and other things? I think in general there's an intuitive case that it's better to know more rather than less, and so therefore knowing about how Congress really works should inform our understanding of statutory interpretation. I think in a lot of cases that's right, and I just want to suggest a few reasons for hesitation, a few reasons why sometimes ignorance is bliss and we might actually prefer to know less about how the sausage is made. And an example of this would be in private contracting, where you often have the following situation. Two CEOs meet at a restaurant, they hash out a deal on a cocktail napkin, one of them takes a picture of the napkin with their phone, and then they go back to the office and they go to their lawyers and say, write this up for us, turn this into a deal. And eventually it filters down to the lowly first-year associate at Cravath, which could be one of you guys someday, whose job it actually is to turn the napkin into a full-fledged contract that two CEOs can then sign. Now, what's interesting here is in this whole process, they could just sign the napkin. I mean, that's the deal that they want. They could just both sign their names to the napkin and say, that's our contract. Or they could alternatively preserve the napkin and staple it to the front to the formal contract that they eventually signed, saying, in case of confusion, see napkin. There are some advantages to that. We do that in various ways all the time because we think that that's really the core of the deal, and to the extent that the junior associate messes up in converting it into contracty language, better that you have reference back to what the CEOs actually worked out and what they had their handshake over before, instead of just trusting whatever might be on the page. On the other hand, we also see reasons why we don't necessarily want to do that. There's benefits to formality. There's benefits to being able to rely on the contract, on the way in which the sort of ambiguous terms in the napkin were converted into slightly less ambiguous terms, but not entirely clear, in working out all the details that generally go into any sort of major commercial contract. That takes skill to do it well, and one benefit of having done it is that we can then rely on all the details that were worked out. Same thing goes on in Congress. You could, in Congress, if you really wanted to, just pass the bullet points. You could, if you want to, staple the bullet points to the front of the bill. In fact, sometimes they do this. There was one statute, the Civil Rights Act amendments of '91 famously said only certain committee reports count as legislative history for this statute, and essentially incorporated them by reference. You have findings and purposes sections in legislation that basically say, here are the 6 things we're actually trying to do, here are the bullet points, and then use that when you're reading the rest of the statute. But they don't always do that. And they don't always do that in part because they want to be able to rely on whatever the work of the junior staffer who converted the bullet points into legislative text was, and we don't want to have a court in a subsequent dispute go back and question how the sort of general understandings and purposes were converted into detail, all the different ways, all the different conflicting purposes were hashed out and sort of made more precise, because we worry that in that possibilities might happen for people misstating what the purposes were originally or saying different accounts of how those purposes were to be worked out. The time to do that is before the vote rather than after. And I just want to give one sort of quick example of how this might work out in practice. So there was the famous litigation King v. Burwell over the Affordable Care Act, the ACA, also known as Obamacare, and its provision that tax credits would be available in states that had an exchange that was established by a state. And the question that eventually went up to the Supreme Court is, does this count states where the federal exchange served as the state exchange in that state, or were they really meaning, no, we only want tax credits for states that establish exchanges on their own? And that some argued that Congress wanted to punish states that refused to establish any exchanges by depriving them of tax credits. I think as an account of what the purposes of the 535 people who were in Congress at the time were, chances are punishing states wasn't really among them. If you're just trying to do a historical survey of did they want to punish these states, I don't think there's very good evidence that they did. But that's not necessarily the right question, because there's a difference in Congress as a group of 535 people, Congress as a social or political institution, and Congress, the legal entity that can act only by virtue of Article 1, Section 7. So, for instance, an agency head dragged before Congress to testify might come home and say to their spouse, like, gosh, Congress had lots of questions for me today. But in fact, Congress had no questions for you. Individual members of Congress who were on a committee had questions for you. And Congress hasn't done anything until the point that both houses pass a statute and the president signs it or vetoes it and they pass it over the veto. That's the only way under the Constitution that this artificial, imaginary legal entity called Congress can take any action, even if Congress, the social institution, makes its displeasure known in a wide variety of ways. And so when we're talking about what law was created by the enactment of the ACA, the answer might well be that no one person in Congress read the 1,000-plus page bill. No one actually had adverted to this particular provision at all, let's assume, after it was drafted. And we can even assume that it was inserted by mistake. So one amicus brief before the court argued in defense of the administration's reading that a staffer had just grabbed draft bill text from a different bill pending in a different committee that was intended to punish states, but that was no longer part of the purpose of the draft that they were working on. They had just picked it up without realizing it. And the question is what to make of that kind of sequence of events. In the private context, often what would happen, sometimes a court would say, well, this isn't something they meant to do. It's sort of like a scrivener's error. We just sort of read past it. But often they would not. Often they'd say, look, the junior associate at Cravath grabbed the text of the last contract between these two parties, assumed that it did everything they needed it to do, did the appropriate find replace to change the dates and the amounts of money, and handed it to the partner for signing, and forgot that there was some detail in the napkin that needed to be included that they didn't include. Normally in the private context, at least according to the Restatement Second of Contracts, we'd say parole evidence rule, doesn't matter what was on the napkin. If we can read the contract, it makes perfect sense as a contract on its own. It's not sort of incoherent in some way. It sort of makes clear what all the terms are. That's what's binding, even though we have a pretty good reason to believe that that's not what at least the two principals originally wanted to do, because they had every opportunity in the world to have their lawyers read it over afterwards and tell them that there was something wrong with it before they actually signed, and they're entitled to rely on the signed copy afterwards to know that that's what was agreed to. Likewise, it might well be that if the staffer grabs, a bill that wasn't quite doing the things that Congress, the social institution, now wanted to do, but was totally coherent on its own terms, and that was the version that got stuffed in the 1,000-page bill that everyone had the opportunity, if not the inclination, to read, then that, in fact, would be the binding law, and that it's up to Congress to watch what it enacts and to see whether the to work out the details itself, and it's important for people to be able to rely on those details once it does go through the Article 1, Section 7 process, is signed and passed by both houses and signed by the president, and becomes the law of land. So all of this is to say that there are some circumstances in which knowing more may not actually tell us anything useful that we need to know about what the law is. It might well be that sometimes we look at the text in somewhat degree of isolation from what people had planned to do thereby, and that there are values that can be important and are safeguarded most by treating the text as something particularly special. Thanks.
Dang, that was 10 minutes exactly. I don't think I'm ready. So, since I taught this topic for the last 21 years, I actually have slides, sorry. What we are usually talking about is what the literature, it's certainly the old-fashioned literature, right, called the use of extrinsic aids. So do you look beyond the intrinsic aid to interpretation is the text itself. Everything Professor Sachs said is correct, absolutely true. The question is, how do we interpret the words we see, and do we use other tools beyond just our ability to read English on a page to interpret actions, to interpret, in a sense, intention? Because I can't actually figure out what somebody wrote me without making some assumption about what their intention was in writing me. Writing is costly. It takes time, might take money. And so if someone's writing me something, including 536 people, because the president's part of the legislative process, that they had an intention behind it. And our question is, what was that intent? Now you're saying, yes, there are 536 different intents. Yes, we cover all this for weeks in my class. It's a really good point. But the fact is, how many of you own a dog? Or used to, or your parents owned a dog or a cat? Goldfish? Hamster? I'm running out of pets. Did you ever, call the dog and it didn't come? Okay, there you go. Didn't you wonder why? So you're in the process of thinking about what your dog's intentions were. Why is the dog doing that? You'll ask questions about your computer. Why are you doing this? And those of us watching you yell at your computer or talk to your computer or talk to a door, an automatic door that's supposed to open and it doesn't, or your car not starting. We watch you talk to these things. We are not fooled into believing that you believe that your dog or the computer have intentions. However, humans apply intentionality to everything. It helps us in understanding everything, and it helps us also in communicating how we're thinking about understanding everything. So you're communicating your problem with your computer by actually attributing intentions to it. I mean, you do all sorts of things like this. For example, you do crazy things like say that you own a virus. I have a cold. You own a cold? You own a rhinovirus? Really? So we use language, particularly intentionality, property, and space. I'm going through a divorce. I'm going through time. I'm going through space. We use language in particular ways to compress ideas so that we don't have to stand there for hours and hours and explain to you why my hair doesn't look perfect today. So that we can get on with what we actually need to do today, which is worry about ourselves. Now, statutes are a form of communication. I'm not yet going to get into who they're communication to, but all communication is sent on a channel. I'm using several channels to communicate with you right now. I'm speaking, which is being broadcast. I'm using my hand, I'm using my face, I'm using slides. So I'm communicating over several channels simultaneously. I would imagine that the 536 people, plus all of their staffs, drafting legislation are communicating over a wide range of channels, which is what creates the problem in trying to understand congressional intent. And again, by Congress, I also, when I'm talking about how legislation's made, mean the president too. Article 1, Section 7, how laws are made, includes the president. Now, all communication has noise. It's not just pure signal, and you have to be able to delete the noise and focus on the signal. And the legislative process, as we've all watched, politics is full of noise. So how do you separate out the signal from the noise is the question. Oh, by the way, the two hot topics in study of statutory interpretation are anachronistic statutes, you know, like the ones that in Portland where the woman got arrested for wearing a dress on Sunday, or sorry, wearing pants on Sunday, because women are still under the law required to wear dresses on Sunday there. And I have no idea why the cop decided to enforce it, but it's still on the books from the 19th century. And the fact is, legislatures never go back and erase old laws, they just add new ones on top. So one problem is these anachronistic statutes. The second problem is, once a law is written, how does the interpretation change? So you have the Food and Drug Administration for 7 decades denying that it had authority to regulate cigarettes, and then in 1996 deciding that, oh, yeah, we have the authority to regulate cigarettes, which led to the case Brown and Williamson v. FDA. So one thing we need to ask, you know, in these signals, which of these signals, since there's so many signals emitted from the political, from the legislative process, which ones can we trust? Well, the suggestion would be that we can piggyback on the establishment of trust between legislators in the process. So legislators, the first people they're communicating to, the first people, these committees with their staff-written legislation, which does happen, although not as a norm, it does happen. Who are they communicating with? Right? What do they have to do first? What does the committee have to do first before its case ever ends up in court subject to interpretation? Anybody? It's like my class. they have to get it passed. They have to get it past their own chamber, and then the other chamber has to get it passed, and they have to get it signed by the president. So the first thing they're doing is they're communicating with their own colleagues. So let's think about that kind of communication and whether we can piggyback on how legislators communicate with each other. So all you need to do is really see, I don't know how to make the laser work. The first line point. When someone's speaking to you, do you listen to people who you believe know nothing about what they're talking about? You are millennials, aren't you? You guys are always hooked to Face Blank or Twitter less or whatever, no, Instabucket or something, you know, one of these interweb devices, right? So if you don't believe that the person has the knowledge you need and can convey it to you, you're going to ignore them. Humans are really good at ignoring things. We ignore 99.9% of all signals we ever receive. You're receiving a whole bunch of information right now. You guys hear the fluorescent lights flickering? You hear the hum of the air conditioning? You feel the pressure of the seat on your bottom, the pressure of the earth moving up through your feet, the pressure of the air pushing down on your body, the sound of rustling behind you as people are getting bored with what I'm saying. There's all kinds of things that you can experience simultaneously. Your senses are fantastic, but you've got an attention block. You can only pay attention to one thing at a time. That's the way your brain works. You try to, you guys ever, I know you would never do this, but I know you've seen people who have text and drive at the same time, right? Trying to do two things at once? Well, you're not, right? You're swapping attention and back on the road and swapping attention to your device and back on the road. It doesn't work out all that well because swapping attention there isn't such a great idea. But you're marvelous at swapping attention. It's because you can only pay attention to one thing at once. Now, in order to figure out whom we can trust, unless you know them really well, we have to figure out, do they have common interest with us, or are they subject to costly action for speaking to us, a penalty for lying if they lie to us, or are they subject to threat of verification for what they say to us? And if any of those things are true, any of those four things are true, we can establish the conditions for trust. So there's all of it. The listener has to believe the speaker's knowledgeable, and then has to believe that the speaker either has common interests with them, subject to a penalty for lying, subject to a threat of verification, subject to costly action, or any combination of those. And then we can trust them. What they say could persuade us, and then we can learn from what they say. So don't need to bother with the experimental results. Oh, that's nice. I spent all this trouble setting this up the right way. Okay, now everybody just turn. Okay. So this is how a bill becomes a law, sideways, which is probably how we should think about Congress. The best laid plans. So what we would want to do, and don't have time today, but we spend about 3 weeks on in statutory interpretation, is figure out which of these spots we should ignore because we don't know if they're telling us the truth, because there's all kinds of falderall that happens in Congress that's not worth paying attention to, and which are the spots that we should pay attention to and focus on those signals to try to get at congressional intent, why they were writing the legislation, to help us figure out how to interpret it. And so I'll leave it at that. Is that less than 10 minutes or thereabouts? Okay.
So I think we'll do just brief responses between the two of us and then open up for Q&A if that works. So I think I would definitely agree with Professor McCubbins that it's immensely important to recognize that there are a lot of figures within Congress who are trusted by other figures within Congress, and the system wouldn't work without that. I think there was, some of the literature on legislative history suggests that what's really going on is a form of deceit where the committee is sort of fooling everyone else into believing their, report on the statute is true. I don't think that that's what's going on most of the time. I don't think that happens virtually at all. I think that the real worry from the sort of formalist perspective is not that the committee is trying to deceive Congress about what it thinks it means, but the question of when are those representations constitutive of what the law is, and when are they just predictions of the kind that any lawyer might make? So if you show bill text to some fancy schmancy partner at a Washington lobbying firm, and you say, "What's this bill going to do to us?" And they say, "Well, I think it would do X, Y, and Z." And a committee can make those kinds of representations too. The question is whether, because it was a committee, those representations are automatically right, because those are the things that the other members of Congress were looking at when they passed the bill, or whether if the same partner at the lobbying firm had written an op-ed for Politico or The Hill that was widely read among congressional staffs, whether that would be constitutive, whether that would sort of determine whether the statute meant X, Y, and Z, because that's what they predicted it would be understood to mean. I think that, in the latter case, in the op-ed case, I think we're generally willing to say, well, it might be really good evidence about what people thought they were doing, but it's not quite the same as determining the content of the statute. Likewise, you'll often see committee reports that will do something like, well, the statute says reasonable attorney's fees or something like that. Here are 3 recent district court cases that decided that reasonable required X, Y, and Z, and we expect it would be similar. You could read that 2 ways. You could read that as Congress ratified those district court rulings and wanted those district court rulings to become the standard. Or you could say, no, that was just what had recently happened, and the statute says reasonable attorney's fee, that has a certain meaning in the law. Maybe those district court rulings were wrong, and if they were, that would just show that that's where Congress was looking, but it wouldn't necessarily mean that the statute has to provide for whatever it was those 3 district courts, which are not mentioned in the text of the statute, had decided. So there are lots of ways in which it's necessary for the process to function, that people be able to speak to one another and trust each other and understand each other, but it's a separate legal question what we do with all of that once the statute's already out the door.
Again, I don't have any problem with any of those points. In my course, and I'm agnostic in my course at least, not in my writings, but we go over the 8 schools of thought of law and the theories of statutory interpretation that follow from each of those. And because you still see every single one of those in interpretations today, and certainly if you read interpretations from 30 or 40 years ago or 100 years ago, you'll come across them, and occasionally you have to do that. Now, the question again comes down to who are the committees talking to? Scalia famously thought that the committees were trying to fool the courts, and so they were writing things that were lies, that changed what the statute was really about just to affect a court's decision. Now, legislators, congressmen, would have to be spending an awful long time thinking about something that's a rare probability that the statute ends up in court, particularly the Supreme Court, and would have to be getting everybody else to go along with the lies as they put them into the committee report. So these committees are not just accidental groupings of legislators. These committees are appointed by their parties in Congress. And so the majority of the committee members are appointed by the majority party. The chairs are appointed, and the minority leader on the committee is appointed by their parties. The chair is appointed by the speaker. They're elected either by the entire majority party or by the majority party on the committee. And these are actually leadership positions within the party. And lots of committee chairs, when they do things wrong, are removed from being committee chair. It happens not every Congress, but frequently. And in some Congresses, you'll have 4 or 5 removed by the membership. You've seen speakers removed recently. You may see a sitting speaker removed again after the election. So leadership is subject to sanction. One of those sanctions would be a penalty for lying, as I suggested. And if they're subject to a penalty for lying, if the penalty is large enough, you're going to exclude all possibility of lying. But then there's also the threat of verification. So there are lots of people, both inside and outside of Congress, who can verify what's in a committee report, including the committee in the other chamber, including members of the administration, including the whips who are in charge of getting this legislation passed. And so since there are lots of avenues for verification, threat of verification is also at work on committees. It's also at work on who we would call the floor manager, whose responsibility it is for the majority party to answer questions about what particular clauses in the bill means when the bill is being considered on the floor. Same is true for conference committees. The same is not true for random members of Congress standing up at 8 o'clock in the morning and speaking their mind. There's no threat of verification, penalty for lying, anything else. Perhaps their constituents will hold them accountable if they say outrageous things, but if they speak about legislation, it's not like anybody's relying on what they're saying, even if they're the committee chair, because they're not speaking as the committee chair at that point, or as the floor manager, who's typically the committee chair, or the subcommittee chair who is in charge of the bill. So there are particular people, and at particular times, like I said, we need to look for the signal and throw away the noise. The rest of it, I know courts have relied on op-eds. Strikes me as crazy, but I know they've done it, right? They rely on floor statements of important senators, even though they're not held accountable for what they say on the floor unless they're in one of these positions. So I understand the courts have done this. The argument I came to make was that unless you're certain that you know whom they were speaking to and was there a condition of trust built between them so that we can act sort of like a fly on the wall and watch that interaction and know whether we can trust it or not to figure out intent, that I would ignore it. But that's not always what the courts do. Oftentimes, the courts have different theories of law than I'd be presenting. Yes, committee reports are not part of Article 1, Section 7. The only thing that's part of Article 1, Section 7 is the law that's passed. Scalia also made that point. Therefore, you shouldn't rely on anything else. But the fact is, as I suggested, we all speak on several channels at once. Congress does as well. And you have to ask your question then, how do agencies fill in the blanks? How do agencies reinterpret statutes to update them when Congress isn't going to pass a new one? And it has to do with the relationship between how Congress is organized internally and how they organize the government externally. And we have to think through those relationships to be able to figure out when we should pay attention to what Congress is saying and when we can ignore it.
Love to hear any of your questions. Yes.
I had a question, I guess, more for Professor McCubbins, but Professor Sachs might also want to chime in on this. Does your argument change at all if the Congress is majority, like vast majority of one party or another, if it's closer to something, some sources become more reliable or less reliable? Do you take things with more of a grain of salt, or does it remain unchanged?
So if they have a constitutional size majority in the chambers, say, you would expect them to be able to much more easily impose penalties on their members for wrongdoing. And therefore you should never see any wrongdoing, which is what we typically see when you have very large majorities. So yeah, it matters, but not a lot. I mean, the biggest thing that happens when you have smaller majorities is not that the committees write committee reports that lie. It's that they write committee reports that are the truth, and it pisses everybody off. And so you get bills coming out of committees that never pass. They never get heard on the floor. And that's irritating for everybody. Or they never pass the other chamber because the speaker just won't schedule it, right? These bills that don't satisfy the majority party do get scheduled. They all get scheduled for December 24th at midnight. Congress is typically out of session at Christmas. So if it's out of session when the bill's scheduled, you just pass it up. Move on to the next day of the calendar.
I have nothing to add in terms of that. Though it's certainly true that the cohesiveness of majorities matters a lot. And sometimes you see, so for instance, in 2009, you had when there were 40 Republican senators, they were much better able to coordinate their actions when they knew that a single defection would make a big difference than the Democrats were at 60, even though for them too, sort of a single defection could make a big difference. But there was, with the sort of supermajority, there was a lot more room for private infighting, one kind or another. But that's a general political trend, not something specific necessarily to statutory interpretation.
And then Scott Brown won, and it just destroyed the whole possibility of the Senate being able to get rid of cloture, invoke cloture.
I wonder if you, either of you have any observations about selective cherry picking, like you look out into a room full of people and you see only your friends, and how courts have dealt with that issue?
Not well. I mean, just in the same way that sort of it's never easy to deal with that issue. It's very, you're always in that position, and you're in that position if you're like writing a biography of Napoleon just as much as if you're trying to figure out what happened in the lead up to the ACA. The things that, the extent to which that sort of factors directly into the legislative history debate depend on the kind of sources you're looking at. And ultimately, the question comes down to sort of what is the margin on which Congress is deciding what things go in the text and what don't. How do they make those kinds of decisions? And why would we, when we see some provision and we think it has a certain meaning, but then we read a couple sources from back then, and we're like, wow, maybe they were actually worried about something very different and not what we thought they were worried about. You're always in the position of having multiple competing, explanations for that. And sometimes it's worth it to undertake the costly effort of putting in more content into the real statute that sort of explains itself better. And sometimes it isn't. Sometimes, it can be more dangerous to do that than not. But that's the risk that the legislature always takes when it decides to pass something. And sometimes it's for very good reasons. So take the example of a legislature passes a bill to ban child neglect. What were they worried about is, failing to complete the religious education of your child, a form of neglect. Like, would it have been regarded as such at the time the statute was passed? Is it regarded as such now? How do we figure out those kinds of questions? They're very difficult. But on the other hand, if you ever wanted to pass a statute fully specifying exactly what you should do, this many calories per day of this distribution of food groups, and, you can imagine how that effort would actually create more problems than it would solve, because we might find out tomorrow that you actually don't need as much, unsaturated fat as we thought, and now we'd have to revise the statute. And so there are reasons why legislatures write statutes in different ways, and just a whole lot of different aims that they have to balance in doing so. And that's true even on an extremely sort of formalist approach to interpretation, because the margin of what goes in the statute and what doesn't is very fraught.
So we spend an awful lot of time and money building the institutions of trust. And they do so in Congress as well. So they build in the costly action, the costly effort to speak. You don't just get to write a committee report because you say you're the committee. You have to serve as a good, loyal member of the party for a long time, get appointed to the committee, work your way up into the committee before you can actually affect anything that happens there. Be a good, loyal member of the party. The speaker, in deciding who the chairs are, and even subcommittee chairs of committees, will write their loyalty score on a chalkboard when they're debating which members will get which positions. And the ones who are more loyal obviously get better positions. So it's costly. And as I said, there's penalties for lying and a threat of verification. Also, if they're from the same party, not perfectly, but at least you know the extent to which you share common interests with them. So you may not share common interest on every issue, so they might not be sharing interests with you there, and so you might not trust them. But you do know on which issues you do share common interests if you're from the same party. And for committees to get things passed, at least in the House and often in the Senate, they have to send the bill through the Rules Committee. And the Rules Committee is controlled 9 members of the majority party to 4 members of the minority party, typically. Sometimes it's 5, depends upon the breakdown in the House. And those members are specifically appointed by the party leadership, particularly the speaker. And so bills don't get to the floor, no matter if a committee wrote it or not. They don't get to the floor without getting a rule out of the Rules Committee, because it's what the Rules Committee is for. It's the gatekeeper. And so the rest of the friends at the crowded party, looking out across the crowded party and finding your friends. I guess I'm not getting the quote exactly right, but I'm suggesting that there are ways to avoid having to look at the entire party, that there are specific people you trust. Or if you're the fly, there are specific people that trust each other in the party, and you can look at what they say to each other and know they were speaking the truth to each other, or have a high probability belief that they're A, knowledgeable, and B, trustworthy, so that you can be persuaded by it. Now, this is if you buy the idea that we should pay attention to committee reports and floor manager statements and reports from conference committees and so on, which again, I have sympathy for Scalia's point that it's actually not part of the law. But Congress creates agents whose job it is to interpret legislation. They govern these agents. They're speaking to them all the time. We want them to have a democratic connection to these agents. And yeah, sometimes that then ends up in court. And the court has to figure out what to do. I'm suggesting there are a lot simpler rules than the courts typically use to figure this out.
One thing I just wanted to ask very quickly is that I think even the most formalist people you see nowadays typically will allow recourse to legislative history in certain circumstances. One is when something is just really old, and we have no reference points to figure out what they meant in the Alien Tort Statute of 1789, other than whatever other documents might have been produced contemporaneously. therewith. Another would be if you have situations of very stark sort of linguistic ambiguity. So this is unrealistic, but suppose Congress had passed a statute and we just couldn't tell whether they used the word bank to mean financial bank or river bank. Now, it's unlikely that you would have a statute where if you read the whole thing, you were still left uncertain as to whether they were talking about rivers or about finance at the end of the day. But if for some reason you were uncertain, it would make a lot of sense to say, well, did the New York Times cover the statute and did they say anything about rivers? And if not, that gives us a clue. Most people in those kinds of circumstances are perfectly happy to look to other documents because they help they help identify what the text was saying in a way that is distinct from, for instance, a particular analysis of the legal conclusions that might follow therefrom. So, for instance, the example of reasonableness I gave before, or, oh, and by the way, don't worry, this wouldn't apply to, this other category, even though we didn't say that in the text. That might be true as a legal argument. There might be legal reasons why there's some implicit exception in the text, but it's a little more dicey when you're looking to other sources and saying they determine what the law is on that question, other than just smart people in and around Congress thought this, so all else being equal, it's evidence that they were right.
Right, is a gravel pit outside of Chicago part of the navigable waters in the United States? Real case, of course. Actually, it's a couple of cases.
Sorry.
Swansea.
Is the presumption against extraterritoriality and the current doctrine on that one of these examples? Because Justice Scalia, I think of all people, in Morrison said we should look at the statutory focus to see what conduct applies and whether it is extraterritorial or not. And then there was a big debate between his opinion and the dissent, and they came up with completely different focuses. So is that an example where including that kind of conduct or that kind of content is just what you need to do, or I don't know.
So I think, to some extent, you're always looking to something outside the statute, and that I would agree that we do attribute some kind of intentionality. Otherwise, even the idea of a legislative bargain is incoherent. I mean, bargains only make sense as between intentional actors doing things for reasons. And so in some sense, you have to say, okay, they struck the bargain here, and we can tell that based on our reading of the rest of the text. You can obviously, there are ways of privileging the text versus other sources. Notwithstanding that, you can say, okay, knowing generally the conditions of the time and the fact that Congress passed this statute, what does that tell us? Versus, this statute with this committee report, this statute with this committee report, and this floor manager speech, and so on. Specifically on sort of presumption of extraterritoriality, there are a lot of doctrines in law that have this particular structure. Namely, we assume that Congress doesn't do X unless they affirmatively tell us so. Sometimes the provenance of those doctrines is a little unclear. Why is it that we make this assumption? Is it just because we think that do we really believe, for instance, in the Charming Betsy canon, that Congress doesn't want to violate international law? I mean, come on, if you took a poll in Congress and you're like we guarantee you this statute will violate international law, people would be like, heck yeah, let's pass it. But nonetheless, we have doctrines like that in our legal system. And the way I argue that they would function, I've written an article with Will Bode on this topic, that these form common law. These are common law rules that are part of the legal system until abrogated, in the same way that the doctrine of duress in criminal law often operates in an uncodified way. And we could look at a statute and we can say, okay, does the statute do anything to the duress defense? Well, sometimes a statute will be written in such a way that suggests that, yeah, even if you have a gun to your head, it's still a crime to violate the statute. And it's not always clear exactly when we make those kinds of judgments, but often we can. Likewise, the presumption against extraterritoriality forms a sort of, ordinarily Congress isn't legislatures aren't regulating conduct that occurs in other territories and other states. And sometimes if they are, they will tell us so. And then the question is, what short of an explicit, and we mean to do this extraterritorially, will we take as a sufficient signal that they really are doing this? And I think that a lot of the work actually is done just from the fact that you look for the thumb on the scale, you look for the affirmative indication, rather than just the sense that the purposes would be best achieved if this regulatory program were more broadly applied, because that's often true. It's often true that the main purpose of a statute is better achieved by applying it in more cases that you wouldn't otherwise expect. But of course, every statute involves tons of purposes, not just a single main purpose. And so it's a dangerous assumption that, as the court has said many times, that whatever forwards sort of the main purpose of the statute is therefore the law.
For every canon of interpretation, there's an equal and opposite canon of interpretation. That's not my line. That's from Llewellyn in the 1922 or something. It's been oft repeated in the literature. And the issue about canons is they're often assumed by the court. Some court makes it up, other courts follow it. The problem I have with all of the canons, the canons should reflect the constitutional and legislative process. They shouldn't just be imposed on top of it. So canons are fine as rules of thumb to help you figure out intentionality or, the meaning of, particularly either confusing or anachronistic statutes. But, we should only have those and keep those canons that reflect the constitutional and legislative process, how laws are made. I guess I can leave it at that. I'll just leave it there.
So I would actually disagree on this point, separately from the merits of Llewellyn's article, which isn't something we can hash through here. But I think that some canons function that way, especially like things that are often called the syntactic or grammatical canons. If we're just saying, how does legalese work? That's a question that can only be answered by looking to how lawyers nowadays speak. And it's just a question of heuristics of, we're just trying to guess at what someone would mean if they were using this particular phrase or this particular, so many canons like, the rule of the last antecedent or something like that is just essentially a gussied up rule of grammar. We think normally when people use words in this particular way, that's how they usually do it, but we might be wrong, and evidence from the statute or elsewhere might convince us that we are wrong. I think that's different from some of the substantive canons, things like the rule against extraterritoriality, presumption against retroactive lawmaking. Many of these are not just guesses about congressional intent, or if they are, they're bad guesses, Charming Betsy being the best example. Many of them, in fact, represent independent rules of common law. And if you approach them as guesses, you're going to sort of get into some very strange situations where, like, well, what do we know about this particular, statute where, for all we know, no one adverted to the possibility that it might be applied retroactively, or no one adverted to the possibility that it might conflict with a particular rule of unwritten law, in the same way that no one might realize that one particular statute might create a danger of impliedly repealing another that's already on the books. But when a court deals with that situation, what they do is they sit down with the two statutes and say, okay, we have a presumption in favor of preserving past law because we assume, as part of the structure of our legal system is that whatever's law stays law until it gets changed. So until Congress tells us, we assume everything else on the books stays in place. Likewise, we might have a rule of law that things that you do with a gun to your head are not crimes, and we assume that until Congress tells us differently. And we might have a rule that international law generally, is respected unless Congress tells us, no, we actually want to override that. And that is a different kind of approach to canons than just as questions of prediction. In that case, you can have a canon that's actually a bad predictor of what most Congresses want to do, but nonetheless has legal force in the same way that the old statutes like, all horses must wear pants or something, stays on the books until they repeal it. And there are reasons why the system would make that so. On the other hand, it also explains why judges should not find it within their, bailiwick to make new canons from scratch, precisely because they have this status as law. Courts aren't supposed to, at least on many approaches, aren't supposed to be generating new rules of law ad hoc as they feel like it. They're supposed to be reporting on rules of law already in place. And in particular, one might think that it's a problem for Congress to pass a statute and then for a court to be like, well, this canon that you never heard of before because we just made it up says that we assume that you meant something totally different. I think that's a real problem, but it's not as much of a problem if the canon is already in the law in the same way that an old statute might be.
Yeah, we have examples of hundreds of canons, as you well know. For example, what's called the appropriations canon, which is I can give you one example. You all know about the Do Not Call Registry. You sign your telephone number up on the Do Not Call Registry. It's supposed to stop people from calling and nagging you at dinner time to buy a set of dinnerware or something. So Congress passed a law called the Do Not Call Registry Act, which the court threw out because for one of the courts, because it was passed in an appropriations bill, which they see as not equal to a statute. Well, frankly, appropriations is one of the types of laws specifically named in the Constitution. So when I say you should pay attention to the Constitution and how laws are made, Congress frequently passes riders to appropriations. It's an easy vehicle to get things onto the floor and passed by both houses of Congress and signed by the president. And to subjugate it and throw it out, even though the title of the act was absolutely clear. Yes, and Congress responded the next day to having the act thrown out by passing we really do mean the Do Not Call Registry Act, and omitting the one thing that a different court objected to, which was they have to allow political speech on your phone. So nagging you to vote for Trump or Clinton this year is, of course, legal because we have political speech is protected and nagging you on your phone is a protected form of free speech. But that's an example of one of the canons which makes absolutely no sense to a Congress scholar or someone who's read the Constitution.